a couple of years ago, I had the privilege of having Mr. Chris Buntel, who is joining me here today as a panelist who provided some very valuable insights on the topic of trade secrets management. And today, Chris is going to be talking about a topic that is titled, I think my trade secret may have just been stolen. What do I do now? And with that, I'd like to welcome you, Chris, to this podcast. And just start by telling us a little bit about yourself and what Tangibly does and how it was started.
Great. Thanks, Mike. And it's good to be here on the mic with Mike, which is kind of funny. But I'm one of the co-founders and chief IP officer of Tangibly, which is a startup company. We're about 4 or 5 years old now, and we're dedicated to trade secrets. So when we formed this company, we saw there's a huge market need, a huge unmet need for proactive attention to trade secrets. People would know how to litigate. Once there was a trade secret problem, people knew how to deal with that. But especially 5 years ago or even longer, people didn't really understand how to identify, manage, and then protect their trade secrets. So that was what the genesis of Tangibly is. Just, can we come up with a way to make it easier, or at least much easier, to do those things with trade secrets, just like people do with traditional forms of IP, like patents, trademarks, and copyrights. So this is a wonderful title and a great topic for me to talk with you about today.
Now, recently, on October the 2nd, there was an announcement made that a company known as SimIP was making a strategic investment in Tangibly. Can you elaborate a little bit about that strategic investment?
Definitely. We're really excited about this investment and the business opportunities it's creating with SimIP. SimIP is a great company, and they're really looking at intellectual property as a valuable asset class, something that you can invest, monetize, and grow as any other valuable form of assets. And traditionally, they've focused on patents as their main vehicle for doing those kinds of value creations. And they really saw an opportunity by investing and working with Tangibly to expand that to include trade secrets. And then from Tangibly's perspective, it's also great because we were, for the last 4 or 5 years, focused on the proactive end of the spectrum, helping people long before they ever have a trade secret problem, or hopefully never have a trade secret problem. But by working with SimIP, it allows us to extend our range of coverage to start to include things that are closer to litigation. So more about dealing with trade secrets when you think they've been stolen.
That sounds great, Chris. Thank you so much for bringing us up to date about that. So, since the topic of today is my trade secret may have just been stolen, that gets into what is trade secret misappropriation. And even more basically, for some of our viewers, it might be helpful just to talk about what the subject of a trade secret is.
Yeah, absolutely. And a lot of people are starting to understand the buzzword about trade secrets, like it's being used more often. You're seeing articles in media, both online as well as traditional. There's more lawsuits. So people are starting to talk about trade secrets, but a lot of them still don't have a real good grasp of what trade secrets actually are. And to look at that, trade secrets are really a form of confidential information. So it's like you have a set and then a subset. And trade secrets, whether you look at different states or US federal or even international, there's always three components that you see in any definition. So the first is that it's not generally known. Basically, it's a secret, which is part of the name. So that's not very surprising. The second one is that it has independent value by being secret. And then the third one, which is where life gets interesting or challenging, is that the owner of that trade secret has to take reasonable measures to protect it. And it's a little complicated because reasonable measures is not defined. You can flip to the next page of the statute or look up in a book or article, And there's no one single definition of what is a reasonable measure. And there's actually good reason for that because a few things. So number one, what resources you have and how much time you have to protect your trade secrets varies from company to company or client to client. And some trade secrets might be incredibly valuable. You could think of the Coca-Cola recipe, the WD-40 formula, the KFC special spice blends. Those are kind of bet the company trade secrets, where if those were lost, it would cause tremendous damage. But then there are other trade secrets that may have kind of moderate value or maybe even have kind of marginal low value. And what you don't reasonably protect all three the same. You're going to protect your crown jewels very strongly, and the marginal ones you'll protect, but less. Also, it depends on just who the client is, who the trade secret owner is. If you're a small startup company struggling to make your next paycheck to your employees, you don't have a lot of resources to put in it. Whereas if you're a huge multinational company with millions of dollars in legal budget and legal teams and just lots of infrastructure, you can protect your trade secrets much stronger. But in all cases, you're doing what's reasonable, but it's very context dependent. And that makes it an interesting topic to talk about.
Thank you, Chris. So now that you've given a very good explanation of what a trade secret is, let's get into some concepts of what misappropriation is. There are different types of misappropriation. There's actual and threatened. And if you could get into your just general understanding of misappropriation and then talk about each of those two types, that would be great.
Well, and even the concept of misappropriation might be something new for some of our listeners. And trade secrets operate quite a bit differently than the other forms of IP. Again, patents, trademarks, and copyrights. Those ones are more of an infringement model. So if you step onto the landmine, bad things happen. And trade secrets are much more like a tort. So it's much closer to theft. Like if I broke into your house and stole your wristwatch or broke into your garage and stole your car, trade secret misappropriation functions much closer to that theft model where there's a thief, they steal something that they shouldn't, and they basically cause you harm. So it's much closer to tort law than what we normally see in intellectual property. Now, the irony is most companies, certainly small, but you'd be astonished how many large companies don't even know what their trade secrets are. Like they just have no idea or a very vague, fuzzy kind of cloud picture of what their trade secrets are. So if they do get stolen, oftentimes they don't even know. If you don't know what valuables are in your house, how will you know if one of them has gone missing? You have no idea. So even just getting your arms around, what trade secrets do I have is an important first step that most people have not yet done. And it still surprises me after years of doing this that we keep hearing that same thing. Misappropriation, it's really important because it can cause a lot of harm to the trade secret owner. Coming back to your original question, you can have actual harm, like a trade secret is taken and is used inappropriately at another company or another entity, as well as threatened. And it kind of makes sense if you step back and think about it, because you shouldn't have to wait until millions of dollars of damage is caused to try to stop it. If you as a trade secret owner suspect that a trade secret has been taken and it's likely that it will be used in a very damaging way, you can take measures at court to try to stop that from happening. You don't have to wait until the blood has been spilled to try to stuff it back in. There are different ways of dealing with an actual trade secret theft versus a threatened one.
Thank you very much, Chris. And that gets us into the next area. Having spoken about what misappropriation is and the two types of it, let's talk about how you can tell even when something is amiss, how you can tell that there's something looks like it may have been misappropriated. Could you get into, how clients can prime themselves to promptly get alerted to situations when they occur like that?
Yeah, it's a great question. And Mike, a lot of it is your eyes have to be open. Like that's kind of the first step is you have to have some kind of system or process to help you detect when trade secrets have been taken or to suggest that something has happened that needs you to do more digging or pay more attention. If you just sit back and let things happen without watching, chances are your assets will be taken from you and you might not even know. Again, I'd say the very foundational step is know what your trade secrets are so you have at least a chance of knowing that they're stolen. And statistically, when we started Tangibly, we started to look at statistics to understand like where the risk of trade secret theft is sitting. A lot of people worry about hackers and thieves and bad people who break in. The reality is about 70% of the time, it's your own colleagues and coworkers that cause trouble with trade secrets. So if you look to the left or the right of you, or the people that you go out to lunch or have coffee with, statistically, they're actually the biggest problem. There's another group about 15% of the time where it's a partner or collaborator. It might be a vendor, it might be a supplier, it might be a university joint development project team where things start out great. Everyone is excited to do a project, excited to make money together, and then something goes wrong. Either the project doesn't work well, maybe they use your confidential information to help other clients that they're not supposed to, but basically something goes wrong in the relationship. And then the final 15% are the hackers and thieves and ninjas that everyone traditionally worries about. And I'm not saying don't focus on like cyber risk because it is really important to pay attention to, but it's really your own people that need attention that you have to watch out for because they're ultimately the biggest risk vector that you have.
So, what are some of the technical tools that are out there that might help some people with trade secret misappropriation detection?
Yeah, and it's a little tricky because like a lot of people change jobs routinely and they change them more and more often these days than ever before. And like you can't erase their brain, unfortunately. When you're switching from company A to company B, you're actually being hired because you are good at your job. Maybe you're a great scientist, a great engineer, a great software coder. And that kind of know-how that makes you a good employee or a good partner is valuable. And you don't want to prevent people from putting food on the table and paying tuition and all that stuff. But at the same time, you don't want them taking confidential, valuable trade secrets with them to their new employer or to start their own startup that ultimately competes with you. So there is a bit of a balance there. And like I said earlier, you can look for suggestions or hints of trade secret problems if you're looking for them. So things like if your employee moves to a new job at a competitor and then 18 months later, patent applications start publishing that look suspiciously like your own trade secrets. That's something to watch for. You can also just watch for employee mobility. If they go to a company in a whole different sector, maybe that's not such a high risk. But if they go to your arch competition, you might want to look more closely. Also look at, new product releases or press releases, any kind of public disclosure that their new employer is making might suggest that there was a trade secret problem. And then, there's different ways of dealing with it. But it's rare that you'll find like a 100% guaranteed risk factor. Like it's all kind of higher risk or lower risk. And you need to decide what to do for elevated risk, especially when it's your own employee moving jobs, because that's the most common situation. And even on that, there's in my mind, there's two different categories. So yeah, in both cases, they're doing a bad thing. So they're bringing trade secrets from your company to another company. That's not cool. That's not a good thing. Some of them, they're kind of good people doing bad things. So like maybe they don't realize that the information is a trade secret. Maybe they were never trained. Maybe they thought it was somehow normal in the industry to bring this information with them. So they're doing a bad thing, but mentally they're not so much a bad person. The other group is truly the bad people doing bad things. And these are the ones you hear about a lot in the media. Someone the day before they quit their job at 3 o'clock in the morning, they log into their computer and download 8,000 files. They know what they're doing. They've planned this. It's invariably right before tendering their resignation. It's usually in the wee hours of the morning in the dark. That's a whole different problem that is also addressable, but in very different ways because they know that they're doing something wrong. The first group is also very addressable through things like training and building a culture, but it's an easier problem because they're basically good people. They just don't realize they're making a mistake. And
Thank you very
we
much.
tangibly we've developed some approaches of monitoring your ex-employees to see where they're going, what kind of patent activity, what kind of publication activity is out there. Again, with an eye towards identifying elevated risk that needs more diligence and more digging. So there are some tools and services out there that allow people to either automate or semi-automate.
Great. Well, thank you for that explanation. And that gets us now into having detected that there might be something amiss. What do we do about it? And the first question I have in that area is preservation of evidence, that we want to try to lock things down. And can you just get into that component of it, what your experiences has taught you about the need to do that and the methods in which some of that might be done?
Yeah, absolutely. I think the very first thing you should do is contact your attorney. So call Mike and say, hey, I have a problem, or I suspect I have a problem. Engaging good outside counsel is the very first thing you should do. First off, they have a lot more experience, hopefully, dealing with these problems than you do. But you also get protection like attorney-client privilege and attorney work product for the investigation. So getting a outside counsel involved early is super important. But you're right, protecting the evidence is important, and getting forensic analysis is often important as well. You want to have a good snapshot of what your information is, access logs for the departing employee, let's say. What information did they have access to? Were they using a platform like Tangiblies that has a lot of information stored in there with time and date stamps of how did that employee contact various trade secrets? What trade secrets were they exposed to? So really preserving that evidence is important in all IP litigation, but especially in trade secrets. Trade secret litigation is also a little special and different because it's fundamentally storytelling. Yeah, patent litigation, yes, there is a story component, but with trade secrets, there's usually a lot more drama and a lot more personal interactions. It's typically one person or a small team that is accused of stealing trade secrets. And just you have to tell a great story if you're the trade secret owner of, trade secrets are valuable to me. I have systems and procedures and software in place. I train my employees, and I'm doing everything that I can to meet or exceed that reasonable measure standard. And then if you're a defendant, of course, you try to pop as many holes in those balloons as possible. But a lot of it is kind of fuzzy storytelling. It's not often as cut and dry as infringing a patent claim. Getting that snapshot in place, getting forensic investigation, especially if people have tried covering their tracks or deleting records or deleting files, having a good forensics team come in can be really valuable.
All right. And so then when you were considering legal action, there's the potential not to just to file a complaint, but also to seek a temporary restraining order or preliminary injunction or both to try to get some early relief. Are there some unique considerations for either a TRO or preliminary injunction consideration that additionally ought to be investigated?
Well, and I think that it kind of depends on timing. So if there's a chance that the trade secrets have not left the barn already, you're more likely to be able to get that kind of early injunctive relief because you don't want to have to wait until the trade secret damage has been done. Like it's kind of a one-way street of disclosure. So, yeah, if you're the trade secret owner, you want to limit that damage as quickly and as effectively as possible. And you don't want the other party, the defendant in this case, to use or disclose or do anything with your trade secret until the court can figure things out.
All right. And then the other thing that a client has to consider is, all right, I really think I want to bring some legal action and I have I do want to bring in an attorney, but man, this is going to be something that's very expensive for us. And there's a real financial consideration to consider and going forward as you're weighing your options. Obviously, if it's something that's completely central to the company, you're going to want to put that forward. But if it's anything less than than actual, this is the only thing we do and it's being stolen. If you're not at that point, that end point in the spectrum, what kind of financial considerations need to be considered or investigated and explored?
Sure, it's a great question and kind of a complex one at the same time. You might suspect that there's a misappropriation or a theft, and you'd contact Mike, you'd do some research, do some digging. You might find that there actually was no misappropriation, or maybe you can get things under control very quickly. Especially if it's not a departing employee. Sometimes you think that there's an elevated risk, but then once you do the digging, you find out everything's okay. Maybe your systems were effective, maybe your training for the employees sunk in, and what you thought was a problem is actually not. I mean, that would be great. And tangibly, we always joke that we hope that our clients never actually have to have a litigation because in some ways, if you've managed your trade secrets appropriately, it will significantly lower your risk of problems down the road. In some ways, it's sort of like fire insurance with your house. Like, we all have fire insurance, but I would be perfectly happy becoming an old man and dying with my house never having burned down. I don't want my house to catch fire, but I feel better that I've taken proactive steps to deal with that should it happen. And it's not a perfect analogy with trade secrets, but it's pretty close. By being proactive and managing your trade secrets, it lowers your risk of having a problem that will bring you into an expensive litigation. Of course, you'll never get your risk to zero, just like I can never fireproof my house 100%. But you can get close to zero. Now, if despite all of that effort and diligence and training, you still have a problem, maybe a bad person did a bad thing to you, litigation is expensive. If you're looking at the full soup to nuts of litigation, it could be $2, $3, $5 million to get to a final conclusion. And for a lot of companies, especially small to medium-sized ones, there's a bit of a financial burden there that they just don't have the resources, or they're a startup company trying to develop product, and they don't have the time or the cash to litigate, especially over trade secrets. Now, there are litigation funders out there. Most of them do patents, but we're starting to see some interest in funding trade secret litigation as well. They tend to work on a milestone basis, but if you can get selected by these funders, that's one way to afford a trade secret case that you wouldn't normally afford. But be aware they tend to be super selective. Like the percent of cases that are brought in the door for evaluation, the percent that gets selected for funding is pretty small. So you need to have a really clear, really compelling trade secret theft scenario to get a good shot at funding. But I think that's something that we'll be seeing more of. It'll be discussed more. And I think as funders see trade secret damages increase, and already they're in the hundreds of millions to billions of dollars of damages in extreme cases, that gets the attention of litigation funders. And it used to be that you needed a patent litigation to have that kind of large recovery. But we're seeing trade secrets meet or even exceed the kind of damage recovery that you would normally have to get through a patent. So it's pretty exciting.
So, can you comment a little bit about how the strategic investment by SimIP into Tangibly might expand Tangibly services in this kind of scenario, like a post-detection scenario, and
Yeah,
where you see Tangibly now going in this expanded role?
sure. I think these are exciting times for Tangibly. In the last 4 to 5 years, we've built a very solid foundation on the proactive management spectrum of trade secret. So, all about identifying your trade secrets, managing them, lowering your risk, and demonstrating the value of a trade secret portfolio with an eye towards either minimizing your chance of litigation or at least positioning yourself to be more effective and have a better chance of recovery in litigation. Now with our relationship with SimIP, we're able to expand that spectrum to be much closer to litigation. Now, the relationship is only a month or two old, so it's still very new. We're still working on how to deploy these great new ideas. But things like, can we help people identify potential cases of trade secret theft, especially if we can either automate or semi-automate those? That would be very helpful both to the clients as well as to law firms like your own. And just have more support for litigation, like as the litigation is proceeding, as well as potentially litigation funding for compelling trade secret litigation. So I think that this really allows us to cover everything from soup to nuts in trade secrets, from helping clients get a policy, something as simple and as foundational as having a policy, training your staff, holding harvesting sessions, which are basically meetings where you uncover and ferret out your trade secrets, all the way through detecting problems and helping clients deal with those problems in a cost-effective manner. We have a lot of great new opportunities that we're starting to explore with SimIP.
Well, these are indeed very exciting times, Chris, and I'm looking forward to seeing how things continue to develop tangibly and on this piece of its expanded services. I thank you very much for the very valuable insights that you have provided today and look forward to maybe continuing to explore some of the areas that we talked about in even greater depth. So thank you
Yeah,
again.
fantastic. And just to leave with a couple of thoughts, one, we have to talk about AI because everyone talks about AI these days. AI has actually been a great thing for trade secret law because a lot of what AI generates is not protectable through normal traditional means. So there's serious issues with AI cannot be an inventor, so it can't lead to a patent. AI cannot be an artistic creator. Copyright law traditionally was used. Maybe that's less effective or ineffective with AI. So the big thing that's left is actually trade secrets. Yeah, AI is moving so quickly that even if you had something patentable or you believe it's patentable, it would take so long to get through the patent office that the technology has evolved 10 times or 100 times at the rate things are changing. So, there's a whole bunch of factors that are really making trade secrets the plan A instead of plan B from traditional forms of IP. It's a whole nother topic talking about AI and trade secrets, but it's something we can consider for the future, or maybe you'll have another speaker talking about AI. But these days are really amazing for trade secrets. And comparing even just the last 5 years or certainly 10 years, it's gone from this rarely discussed form of IP to something that is on the forefront of everyone's minds. So I'm very excited, as you can tell. I think Tangibly has a great SaaS platform and great consulting services, and I'm really proud of what we're doing. These are exciting times to be in.
Excellent. We'll definitely be looking to see where things develop there and explore things further with you. And again, I very much appreciate your taking time out today to give us this information in this podcast.
Awesome. Thanks, Mike.
All right. Bye bye.
Bye.